Hey everybody, Bill Sack here, your favorite attorney with the Firearms Policy Coalition legal team. We've got some huge gun news out of California. A ruling has been issued in the FPC case Miller v. Bonta, known formally as Miller v. Becerra. The ruling, a massive win for gun owners, strikes down California's assault weapons ban on the grounds that it's unconstitutional. So what did the opinion say? What's the current state of the law in California? And where do we go from here? Well, this past Friday, Gun Violence Awareness Day no less, United States District Judge for the Southern District of California, Judge Benitez, released his 94-page opinion in this landmark case, Miller v. Bonta, a case envisioned, assembled, and litigated by your FPC legal team, which challenged the constitutionality of California's assault weapons ban. And, while I hope to give you a quick overview of the opinion here, the good news is that Judge Benitez wrote the opinion in plain English for anyone to be able to understand. So let's get started. From its outset, the opinion made clear, firearms deemed assault weapons are fairly ordinary popular modern rifles. This is an average case, says the judge, about average guns used in average ways for average purposes. Judge Benitez continued, the Second Amendment protects modern weapons. The firearms banned by California and deemed, quote, assault weapons are modern weapons. The opinion also noted that the assault weapon epithet is a bit of a misnomer. These prohibited guns, like all guns, are dangerous weapons. However, these prohibited guns, like all guns, can be used for ill or for good. They could be just as well called home defense rifles or anti-crime guns. While the state ought to protect its residents against victimization by a mass shooter, says the judge, it ought also to protect its residents against victimization by home invading criminals. Friday's opinion acknowledged that the landmark Heller decision draws a distinction between firearms commonly owned for lawful purposes and unusual arms, adapted for unlawful uses, as well as arms solely used for military purposes. As applied to the California ban, the Heller test asks, is a modern rifle commonly owned by law-abiding citizens for lawful purposes? For the AR-15 type rifle, the answer is yes, says Judge Benitez. The overwhelming majority of citizens who own and keep the popular AR-15 rifle, and its many variants, do so for lawful purposes, including self-defense at home. Amongst the expansive and thorough exploration of facts and evidence regarding the commonality of modern rifles, Judge Benitez pointed out, in 2008, over 900,000 Ford F-150 pickup trucks were sold. Twice as many modern rifles were sold that same year. Imagine, says Judge Benitez, every time one passes a new Ford pickup truck, it is a reminder that 2 new modern rifles had been purchased. That's a lot of modern rifles owned by a lot of Americans. Applying the Ninth Circuit's two-step Second Amendment framework, Judge Benitez held that California's ban fails both strict and intermediate scrutiny because it lacked a reasonable fit. Calling California's ban a continuing failed experiment, which does not achieve its objectives of preventing mass shootings or attacks on law enforcement officers. And adding that the evidence suggests it has made no difference at all. Ultimately, because California's ban burdens substantially more protected activity than is necessary to further the government's stated interest, and California failed to consider alternative solutions that didn't infringe on the constitutional rights of Californians. The ban, therefore, could not survive constitutional scrutiny and, as a result, had to be struck down. So where do we go from here? Is this another Freedom Week? Well, in his order, Judge Benitez stayed his decision for 30 days to provide Attorney General Bonta time to file an appeal if he so chooses, which means that for now, all of the relevant laws under the ban are unfortunately still in full effect. The 30-day period ends, believe it or not, on Independence Day. Should the Attorney General appeal this case, he can then ask the Ninth Circuit to continue the stay during the appeal. We will, of course, be watching the docket closely, and when California chooses to appeal, we'll be ready to defend our historic win in the Ninth Circuit. You can help us prepare for that upcoming fight by visiting joinfpc.org. Make no mistake, this victory is a big deal, But we need to keep the ball rolling to continue building the momentum we need to keep the tyrants on their heels. I encourage all of you to read the full Miller opinion on fpclegal.org. Remember, Judge Benitez wrote this in plain English. Anyone will be able to understand it. Head over to fightatf.com to submit your comment opposing ATF's proposed rulemaking on unfinished frames and receivers, and then check out fightchipman.com, where we need you to tell your senator to vote against the confirmation of Dave the Waco Kid Chipman to the director of the ATF. I'm Bill Sack, your favorite attorney with the Firearms Policy Coalition legal team.